I'd like to welcome everybody to the first of four social care webinar series produced by Landmark Chambers. The next ones are on the 23rd of July, the 30th of July, and the 6th of August. And today, what we're going to cover service provision decisions, ordinary residents, and coronavirus. So the first speaker I'd like to introduce is Yasser Vanderman. He was called to the bar in 2012, and in that relatively short time, he's become a go-to public law barrister with a really impressive record of cases all the way up to the Supreme Court, from property and protest to planning, immigration and social care, most recently upholding the government's decision to allow early medical abortion pills to be taken at home during the COVID-19 pandemic against challenge brought by Christian Concern. He's on the Attorney General's panel of counsel and is also instructed by local government, public authorities, commercial organisations, and of course, families and individuals. He's a contributor to both the Legal Action Group books, Adult Social Care Law and Children's Social Care Law. And today he's going to be talking about service provision decisions. And so now I'm going to switch myself off and hand you over to Yasser.
Thank you so much, Stephen. Very kind words. And good afternoon, everyone. I will be speaking on the topic of service provision decisions. Quite an enigmatic and all-encompassing title, and as I only have 15 minutes, I'm going to focus on a couple of areas that I thought particularly interesting and topical. So I'll be talking first about decisions involving personal budgets, and then direct payments, and the related topic of direct payments, and particularly the problems of misspending, and then briefly touching on COVID-19. Looking then at personal budgets, I'm going to gallop through the statutory machinery and then look at how some complaints have been dealt with recently by the Ombudsman. Now, as I'm sure you all know, care and support is dealt with in Part 1 of the Care Act 2014. Various provisions relating to assessment, and then we have Section 24, which says that where a local authority is required to meet needs or decides to do so, it must, amongst other things, prepare a care and support plan for the adult. Section 25 then sets out what care and support plan must contain, and that obviously includes the personal budget, which is dealt with in more detail in Section 26, which you see there. The personal budget must contain the cost to the local authority of meeting those of the adult's needs which it's required or decides to meet, the amount which, on the basis of the financial assessment, the adult must pay towards the cost, and if, on that basis, the local authority must itself pay towards the cost, the amount which it must pay. What does it all mean? Well, its purpose is to enable individuals to exercise their own autonomy to choose how their needs will be met. If one, given a numerical figure showing how much care you need, you can best decide where and how that should be spent, well, within limits. And we see this reflected in the statutory guidance. I refer there to Section 78 of the 2014 Act, which is merely a reference to the provision which says that, which requires local authorities to act under the guidance published by the Secretary of State. And we see there that it says, point of personal budgets is to enable greater choice and control over how care and support needs are met. And in terms of the process, how's the personal budget arrived at? Well, there's lots of useful information in the statutory guidance, chapter 11 of the guidance, which deals exclusively with personal budgets. And we see there that it talks about how important it is to be transparent with the individuals to show how the budget was calculated. And also the provision of an indicative ballpark figure at the start of the process to help develop the plan. And then 11.7 goes on to talk about how the wishes of the person must be considered and respected, and shouldn't assume that people are forced to accept specific care options, such as moving into care homes, against their will, because this is perceived to be the cheapest option. Well, and so what should end up in your personal budget? Well, we see this again in the statutory guidance. It must always be an amount sufficient to meet the person's care and support needs, and must include cost of the local authority of meeting those needs. And then this must be broken down into the various sections. And importantly, paragraph 11.22, local authorities should not have arbitrary ceilings to personal budgets, result in people being forced to accept and move into care homes against their will. And then the method of calculating the personal budget is obviously hugely important. And we see what is said about this given in the statutory guidance again. And we see at 11.24, it talks about the amount being sufficient to meet the person's needs, and must also take into account reasonable preferences. And then paragraph 11.25 is a really important paragraph, and it talks about when establishing cost to the local authority, one must consider local market intelligence and cost of local quality provision to ensure that the personal budget reflects local market conditions. We'll see that in one of the complaints we look at in a moment. We'll see how important that provision is. So that's the statutory position. I think probably most of you know that on the back of your hands. And when you read it in the statute and the guidance, it looks pretty straightforward. But in the real world, things obviously become much more difficult. Now, I've come across a number of decisions of the local government and social care ombudsman, which I think are really useful in delineating the limits of what is acceptable. Useful for individuals, so you can know when a decision is worthy of challenge, and also useful for local authorities, so you can know when your practices are vulnerable to challenge, when you're on the right side of the line and when you're on the wrong side of the line. And the first one relates to a decision of Wiltshire Council, a decision of the Ombudsman from a couple of years ago. Wiltshire had a policy of placing people into bands and then paying in line with the banding levels, regardless of precise need. And for Mr. P, this had the effect of reducing his support when he moved from one local authority to Wiltshire. Now, the Ombudsman concluded that this approach did not accord with the Care Act, and it was said that the maximum budget levels could not be set. Because the Act says eligible needs must be met no matter what the cost, and the bandings could be used as a guide at most. This is just a reminder of how blunt approaches to calculation will be knocked back, and emphasising the need for a more tailored approach. Next then is a complaint made against the decision of Lancashire, and you'll see that this decision also dates from a couple of years ago, and the complaint related to top-up fees, i.e. the difference between the personal budget and the actual cost of the home. Now, the council charged Mr. B a top-up fee for care in a residential care home without offering an alternative care home at a lower rate. And the Ombudsman, when this was challenged, the Ombudsman found that the local authority were not entitled to do that. If the individual had a range of options and wanted a more expensive setting than one that exceeded his personal budget, then a top-up fee could be requested. But if there was no suitable accommodation available that could be paid for within the bounds of the personal budget, then the budget would have to be adjusted so that care in the more expensive setting was provided. And the important thing, of course, being that the person's needs had to be met. And we see some of these paragraphs of the Ombudsman's decision. The Ombudsman considers that for families to make an informed choice of care homes, councils must demonstrate that an alternative care home is available at a rate within the user's personal budget. If they don't do so, then they won't be entitled to charge top-up fees. And that was the case here. Finally, on personal budgets then, a complaint involving the London Borough of Havering. And this is an Ombudsman decision dating just from a few months ago, from September 2019. And in this case, Mrs. Y had to top up the funding provided for her live-in care because all the agencies on the list given by the council charged higher rates than council rates. And again, when this was challenged, the Ombudsman upheld the complaint and found that the council had not acted in accordance with the Care Act or statutory guidance. this is another example, I think, of an individual whose budget simply did not stretch to cover the cheapest option that was practically available to them. And it goes back to what we saw in paragraph 11.25 of the statutory guidance, which is that it's essential to look at the local market and see exactly what could be obtained within the individual's personal budget. That's personal budgets then. Moving on to the related topic of direct payments. And I'm going to be focusing here on issues relating to misspending. Now, direct payments involve transferring the money the local authority would otherwise have spent on that individual's care to the individual, so they are in charge of the money, employing personal assistants themselves, etc. And it goes without saying that local authorities have to make sure that these sums are being used for the correct purpose. Now, first, the statutory machinery. We see section 33 of the Act dealing with direct payments, the condition on which they are granted, and the power of local authorities to terminate them and require their repayment if necessary. Now, the statutory guidance has a long chapter on direct payments, and that's chapter 12 of that document. And on the issue of terminating direct payments, it's quite robust in saying that direct payments should only be terminated as a last resort or where there's a clear and serious contradiction of the regulations. It also talks about local authorities taking all reasonable steps to address any situation without termination of the payment. And then if terminating direct payment, the local authority must still ensure there's no gap in provision of care support, but that and if that step is taken, then there should be a period of notice. But otherwise, apart from those few statements, there's not much for local authorities to go off when auditing payments and making decisions on misspending. That's why I think it's really useful to look at ombudsman decisions to see how these issues crop up, how they're treated. And again, I've looked at 3 recent decisions to give you a flavour of what has been found to be, in those instances, unacceptable. And bear in mind that there are obviously lots of complaints that the Ombudsman has dismissed in the last couple of years because it was found the local authority was entitled to terminate direct payments or to require repayment. But the ones I'm going to be looking at now are the ones where the Ombudsman has upheld the complaint because I think, frankly, that's a more useful way of learning what you can and cannot do. The first involves a complaint against Nottinghamshire, and the decision is recent, November 2019. Now, of course, local authorities are supposed to undertake annual reviews of direct payments to make sure they're being used correctly. But in this case, the council had undertaken a review in 2013, but otherwise failed to do so between 2012 and 2016. And it then, at the end of that period, demanded repayment of £53,000, a large sum of money, for 2 reasons. First, the failure of Mrs. B to provide wage slips for care provided by her husband, which amounted to 25 hours per week. And second, for the misuse of funds, and although the decision doesn't go into detail as to actually what that is, the tenor of the decision suggests that it was more a case of payments being a bit unsuitable for her needs as opposed to bad faith in spending. And in this case, the Ombudsman upheld the complaint and found that none of the £53,000 should be repaid. In relation to the wage slips, the Ombudsman was actually quite damning, and it was said that no consideration was given to the fact that although the wage slips had not been provided, the council did not dispute that the husband had actually provided the 25 hours of care per week. And there'd also been no opportunity given to Mrs. B to discuss the findings or give extra evidence. So really bringing out the procedural problems with the council's decision-making. And in relation to misspending, the Ombudsman accepted that the council had cause for concern, but the problem here was that these concerns had not been raised in the 2013 review, and of course there'd been no reviews in 2014 or 2015. So Mrs. B had no idea that the council was unhappy with the sorts of things she was using her direct payments for, and in fact, having been given the okay in Clean Bill of Health in 2013, she had every reason to believe that the council considered her spending acceptable. So really important here to emphasise that the Ombudsman accepted that the council in substance had legitimate concerns. The wage slip should have been provided, some of the spending was questionable, but the council got into trouble essentially for avoidable procedural reasons. Decision-making could have been fairer, taken into account the relevant considerations, further discussions with the individual, carrying out regular reviews, and warning Mrs. B at an early stage. The next complaint, the one against Lambeth, with a decision from this time last year, various issues in that case. One of the council's concerns was that direct payments were not being used as set out in the care and support plan. In particular, Mrs. A repeatedly had failed to have two carers at the same time, organised regular visits as opposed to sporadic ones, and sought out certain training for her carers. And notwithstanding the very real and understandable concerns from the council, the Ombudsman found the local authority had failed to consider less extreme options before terminating her direct payments. For example, referring her first to a direct payment support service. And importantly, this was the case notwithstanding that the local authority had advised and even warned Mrs. A on several occasions that she should be arranging care in line with its recommendations that had been given. So this is another case where the Ombudsman is emphasising to local authorities the importance of jumping through all of the procedural hoops, even if there are legitimate concerns, before taking the ultimate steps of termination or seeking repayment. And the final case is a complaint against Buckinghamshire from last year. Similar fact pattern, Mr. P's direct payments were stopped due to perceived misuse of funds, despite no review taking place and no advance warning. And we see there on the slide there that what the perceived misuse of funds were in relation to religious classes and sessions, sports, fuel and reflexology. And I think probably from similar decisions, you know where this is going in terms of the Ombudsman's decision. And the Ombudsman quite straightforwardly upheld the complaint, saying that there should have been a formal review before the direct payments were terminated. The issue should have been explored with Mr. B, with discussions and advice about what could and could not be spent, and then there should have been warnings if the advice was not taken, but these things did not happen. And paragraph 86 is interesting by the Ombudsman and encapsulates the intention inherent in the regime, where he says, from my perspective, the plan was quite vague, and that's not necessarily a criticism. The guidance asks councils to do two somewhat contradictory things: to make a plan for how the money is to be used, but also to ensure the person is given freedom and flexibility to use the money as effectively as possible. Nevertheless, it's evident that the lack of clarity in the plan caused uncertainty for all concerned, including Mr. P in this instance. So interesting comment from the Ombudsman about the inherent tension. And this ties loosely into the final topic I just wanted to touch on, and that's the issue with direct payments during the pandemic. Now, the problems here are obvious and they've been well publicised, and I'm sure you'll be well aware of them. And that's if you're in charge of organising and paying for your own care, and you're used to having the same activities, the same people caring for you, that suddenly becomes very difficult in the middle of a global pandemic, where movement is severely restricted, leading to inability to go to classes, shortages of PAs, because they're self-isolating for whatever reason, and lack of PPE, to name just a few of the issues. Now, the government's guidance came out in April, and so it's been around for a while, and the headline points were that the direct payments were to continue as before, and importantly, it was said that local authorities should allow the most flexible possible use of direct payments. In other words, an individual, if necessary, should be allowed to pay for items that may not strictly be on their plan, as long as reasonable decisions are being made. And also that although this should usually be agreed with the local authority, it is recognised that this will not always be possible every time. So just to flag up that this further exacerbates the tension that I talked about earlier between wanting to allow flexible use of the payments on the one hand, but on the other hand still making sure that it goes towards meeting needs as set out in the plan. And for individuals, I would say if you think it's appropriate to spend payments on things you wouldn't usually be spending your direct payments on, very important to try and speak to your local authority first. But if not, you will likely have more wiggle room than before. And as we've seen in the Ombudsman cases, you're likely going to have discussions with the local authority and then warnings if you're on the wrong side of the line before your direct payments are terminated or repayment is demanded. And for local authorities, it goes without saying that you're going to have to show more flexibility. Now, it's not difficult because you want to be flexible to those who need that, but you don't want bad faith actors to take advantage of the situation. Now, and the important thing is to jump through the procedural hoops and not take rash decisions, because as we've seen from the Ombudsman decisions, make sure you conduct the reviews. If you think payments are being misused, even when being as flexible as possible, then you need to discuss this with the individual. and then move on to warnings, terminations, and repayments if necessary. But as long as you make the decisions in a measured way like that, then the Ombudsman is unlikely to uphold a complaint against you. So I think that's my talk. Thanks very much for having me. I'm now going to hand back to Stephen and then Leon.
Thank you very much, Yasser. And Yasser is going to be really happy to answer any questions that people have, as we'll all be really happy to do that at the end. So thanks, Yasser, for that. The next speaker is Leon Glenister, who was called to the bar in 2011. And as with Yasser, in that relatively short time, he's clocked up an incredibly impressive record across the public law field, all the way up to the Supreme Court and even the European Court of Human Rights in social security cases, withdrawal of life support, health closures, planning, and above all, I think in education and social care, where he's one of the go-to barristers. I think it's fair to say that those are where his main interests are: social care, education, court protection, health. He's always in the SENDist and is co-author of the Noddy's Guide to SEN, which is the only book about SEN I can understand. So very glad about that. Like everyone at Landmark, he advises and represents across the whole range of clients, which is reflected in the fact that he's on the Attorney General's panel and also the Equality and Human Rights Commission's panel. And as with Yasser, he's a contributor to both the LAG books, Adult Social Care Law and Children's Social Care Law. And he's going to talk about ordinary residents.
Thanks very much, Steve. Yes, so I'm going to be talking about the somewhat familiar concept of ordinary residents that seems to come up far more than it should. One of my colleagues, David Locke, gave a talk shortly before he appeared in the Cornwall case, which I will come on to, and his talk was entitled, "How is it that difficult?" And that really is one of the themes of this whole topic. The rules on ordinary residents are a bit like those on social distancing. They may initially look quite simple, or the concept seems to be quite simple, but somehow behind it, it gets very complicated. But if Dominic Cummings has taught us anything, it's that some cases really are that straightforward. So turning to the structure of my talk, I will primarily be addressing the test in the Care Act 2014, but what I will do is at the end briefly touch on the test for education duties for young people. So that's those, in terms of adult social care, those will be 18 to 25-year-olds who have an EHC plan, because the test is slightly different. So we begin with the Care Act 2014 and the concept of ordinary residents. It arises, or the concept arises, from section 18, and it is that section which places the duty on the local authority to meet an adult's needs for care or support if the adult is ordinarily resident in the authority's area, or as an alternative, is in the area but of no settled residence. But parking that second point for the moment, today we'll be looking primarily at ordinary residents. And there are two types of ordinary residents. The first is actual ordinary residents, resulting from the situation where an individual is in the local authority's area. And there is also deemed ordinary residents, which I'll explore in due course, but is broadly where an individual is not necessarily in the area of the local authority, but statute or otherwise deems them to be ordinarily resident, and therefore the section 18 duty arises. So I'll deal with that in due course. So starting with actual ordinary residents, and also starting with individuals that have capacity. This is broadly the most straightforward point. And the key case is Cornwall, which I've already mentioned. And to demonstrate the intricacies and the complications that can arise in relation to this area, it's a useful sort of example of what can happen. So in this case, P lived in Wiltshire and was cared for by his parents until Wiltshire Council placed him with long-term foster carers in South Gloucestershire. So we've got Wiltshire and then we've got South Gloucestershire authorities. P then remained in South Gloucestershire until after they were 18, and then they were placed in Somerset under the National Assistance Act 1948. But in the interim, the parents had moved to Cornwall. So we then have the fourth local authority, the third and fourth being Somerset and then Cornwall. And unfortunately, my Zoom skills are not sufficient to try and do a straw poll on this and where that individual is ordinarily resident, but it would be interesting which one of the differences between doing these seminars in person and on Zoom. But I'll come back to the outcome of that case. But what that case did set out is the test, or it approved of the test that was previously set out in a case called Shah as to how to determine ordinary residence. And the Supreme Court set out, paragraph 41, ordinarily resident refers to a man's abode in a particular place or country which he has adopted voluntarily, so that's the first bit, voluntarily adoption, and for settled purposes as part of the regular order of his life for the time being, whether of short or long duration. So that's the second element of the test. And it was noted that settled need not be indefinite, so staying for education or business is sufficient. So when you might go to university, for example, it could be said on the facts that they are ordinarily resident at the location of the university rather than at their parents' address, but it will all be fact dependent. Some more guidance then, we see the Mohammed case. Oh, I do apologise, I have not gone over two of the slides, so we're catching up. You'll see the test there in Cornwall. So moving on, we get some more guidance. This is in the Mohammed case, Hammersmith and Fulham. So what appears to be critical is where a person voluntarily eats and sleeps as a matter of fact. And the example is given, someone working in a farm temporarily and living there may be ordinarily resident in that area. And it may be the case that someone has more than one ordinary residence, but in that kind of case you've got to decide where that person has the strongest link, and that's the Sunderland case there in the second bullet point. So we go back to Cornwall, and apologies for the not giving you the slide initially, but we're back with Cornwall. And what was the outcome? Well, we have three decision makers and three different decisions. So the Secretary of State determined that he was ordinarily resident in Cornwall. And if you recall, that was where the parents had moved to after P had already been placed elsewhere, because they used the parents as the base for ordinary residence. The Court of Appeal said, no, that's not correct. The ordinary residence is South Gloucestershire, where, if you remember, P was ordinarily resident with the foster carers, and that was before they were then placed in Somerset. The Supreme Court said, no, both of those are wrong, and actually P was ordinarily resident in Wiltshire, and that is the original home of the parents. And the test is where P lived voluntarily, and they then brought out this exception, which I'll come on to a bit later, but where local authority places someone in another local authority's area, it is not sufficient to move ordinary residents. So P remained ordinarily resident in Wiltshire, but that shows how some of the complications can arise. So that then deals with ordinary residents of those with capacity. So what about those who do not have capacity? Because the difference here is that if you do not have capacity, you cannot voluntarily adopt a place of residence. And that, if you remember from the Cornwall case, is the first element of the test of ordinary residence, because you can't voluntarily adopt. And essentially what the Supreme Court did in Cornwall, it did discuss this, but adopted the same test, but dropping the voluntarily adopting part of the test. So it set out in paragraphs 45 to 2nd broadly that the test, and this is the second bullet point, is that a person lacking capacity to choose where to live will be treated as ordinarily resident in the place where they have lived on a settled basis as part of the regular order of their life for the time being. So that's how we deal with those who do not have capacity. Some factors to consider are given in the care and support statutory guidance. So that describes things like physical presence will be relevant, the purpose for which the person without capacity is staying, the connection to the area, duration, that person's wishes and feelings. So all of those will be taken into account in the factual matrix to determine ordinary residence. And this is again for those who lack capacity. So that deals with the concept of ordinary residence arising from presence. We then moved on to deemed ordinary residence. So this is where an individual is not necessarily present in a local authority area, but is deemed to be ordinarily resident for the purpose of the Care Act. Now, in terms of legislation to look at for deemed ordinary residents, just to do a bit of a checklist, what you need is section 39 of the Care Act read alongside the Ordinary Residence Specified Accommodation Regulations 2014, and that sets out what are known as the deeming provisions, whereby a person accommodated somewhere will be deemed in another local authority's area. And there are 5 I'm about to cover. The first one there in the second bullet point is where an adult has a need for care and support that can only be met in a care home, shared lives accommodation, or in supported living accommodation, and is placed by local authority A in the area of local authority B, that adult remains ordinarily resident in local authority A. And that's set out in section 39. There are some sort of quite specific points in relation to that, and I'll direct you to the statute if you're dealing with that, but that's the general principle. And just to note, that is a reversal of what was happening in practice prior to the Care Act 2014 coming into force. The second deeming provision, also in section 39, is where an individual is detained under the Mental Health Act, any aftercare services provided under sections 117 of the Mental Capacity Act are to be provided by the local authority where the person was ordinarily resident prior to the detention. And the person is treated, therefore, as being ordinarily resident where they were before they were detained. So that's a specific point on section 117, aftercare services. The third deeming provision is where an adult is provided with NHS accommodation. So that may be care homes, it may even be a stint in a hospital. But in that case, an individual remains ordinarily resident where they were resident before the accommodation was provided. So if you go into hospital in an area that's not where you live, you will remain ordinarily resident in your home, essentially, not the hospital. Number 4, deeming provision 4, and this is a different section, just to flag it, section 74, but where a prisoner is detained in a prison or connected to the criminal justice system, an adult residing in approved premises or residing in premises for bail, then they are ordinarily resident in the area of the prison approved premises or the bail premises. And so that, if you think about that, that reverses the position, the general position, because to be ordinarily resident somewhere, you've got to have voluntarily adopted that location. And if you're in a prison, you haven't voluntarily adopted the location where you're living. But this reverses that test, essentially, deemed provision 4, and puts you as ordinarily resident where the prison is. Now, that is not an answer to where you are ordinarily resident when you are released, because that's a fact-sensitive decision at that time. So it doesn't carry over to when you're released. The 5th deeming provision, which is non-statutory, and this is the effect of the Cornwall case. What the Cornwall case said was that where local authority A places an individual into local authority B's area pursuant to the Children Act 1989, or by extension of the law at the time, the National Assistance Act, then that person remains ordinarily resident in local authority A. Now, there's been no law on that as to whether that applies to the Care Act. One assumes it would. It is extra statutory. There is no exception or deeming provision in the statute. Lord Wilson, who was dissenting in Cornwall, called it judicial legislation. So it is somewhat controversial, but the principle at least would seem to apply. If you place someone out of county specifically for the Children Act, then they will remain ordinarily resident in the first local authority where they were originally. So what happens when there's a dispute between two local authorities on ordinary residence? Well, the statutory answer is in section 40 of the Care Act, and the Secretary of State will then make a determination. The procedure that is adopted is in regulations, which are there on the slide. Now, the Secretary of State keeps a bank of these decisions, just for your information. So if you are interested in or trying to find comparative cases, then there is a bank of those decisions online. And the Secretary of State's determination can then be judicially reviewed if a party disagrees with it. But this process can be somewhat slow, which is why, and here's the plug, Landmark Chambers run a dispute resolution service in this respect called Who Pays, where essentially two authorities, or maybe two CCGs, or in respect of adult social care, children's social care, or health or education, two local authorities can refer the matter to a barrister who then acts as an expert or arbitrator essentially between the two parties and determines where the party or where the individual, is ordinarily resident. And there are various options. It can be binding or non-binding, but to say that option is on the table, and it can be much cheaper and quicker than using the Secretary of State. Just to say, there are two overarching points in relation to dispute resolution I just want to say. One is that there is a consistent line of case law where the court has criticised and does not like disputes between public bodies over public money, because it is spending public money to chase public money. It's throwing money, trying to chase money. And so, if at all possible, local authorities should be using alternative dispute resolution to try and resolve these matters outside of the court process. So that's the first overarching point. The second overarching point is, again, there is a consistent line of case law, and this is also in the guidance, is that individuals should not be left in the middle of disputes between local authorities. So the priority, if there is a dispute, is to ensure individuals get the provision that they need, and it's not scuppered or delayed because of a dispute, and that always has to be the priority. Make sure the individual has the provision, and local authorities can then sort it out amongst themselves and recoup, etc., further down the line. So lastly, what I want to cover is the test on residence, or the test for responsibility, I should say, in relation to education, health and care plans. And some or many of you will be more than familiar with education, health and care plans. They essentially set out the education, social care and health needs and provision of children and young people. And the regime operates up to the age of 25 potentially, and therefore in terms of adult social care you will have a cohort of individuals between 18 and 25 who have EHC plans. Now, the duty to maintain and deliver provision in an EHC plan is set out in the Children and Families Act 2014. It's not the Care Act, it's different legislation. And that test as to who's responsible is in section 24, and it's if he or she, the individual, is in the authority's area. Now, many of you who deal with the Children Act will recognise that test in the area, because it's what arises in relation to the duties under the Children Act 1989. But there is a clear difference, because the case law is clear in respect of the Children Act that a child can be in the area of two different authorities. So if a child either is resident between two parents, or even is resident in one area and then goes to school in another area, that child can be in the area of more than one authority. That logic doesn't apply here, because only one authority can maintain an EHC plan. And so therefore, and what I say, and this is the second bullet point, the test is something more than merely presence in an area. It must involve a degree of stability and connection to the area. There is, however, very little case law on it, and it's not been looked at authoritatively by the court. So we are still slightly in the dark, but that's the direction of travel I would suggest. Note the maintenance of the EHC plan. So section 24 applies to who is administratively responsible for, and who's responsible for delivering the provision. That's sometimes a different issue to who is financially responsible, and that remains a matter that is governed by what are known as the belonging regulations, which are those set out in that final bullet point there. And there are various deeming provisions in that, but that sets out generally the financial responsibility for delivery of EHC plans. So on that note, I'll hand back to Stephen, who will take the last talk.
Thank you very much indeed. That was really interesting. And I mentioned questions a little while ago. I think if anybody's got questions, a good way of introducing them is to use the chat function at the bottom of the screen, so I'm told. So I'm going to talk about coronavirus and social care, and the talk is going to be divided into two. First, I'm going to look at how local authorities might operate adult social care during the coronavirus. Second, and more briefly, I'm going to look at how local authorities may deal with the market, which in many areas, of course, is in a fragile state, or I should say a more fragile state than usual. As far as concerns the Care Act easements at the moment, as far as I'm aware, no local authority is applying any of them, and hopefully that will remain the position. But we're not out of the woods yet. Winter's on the way. Some local authorities, I believe, still need to operate flexibly, and in the future, one or more may feel they need to go further and operate the easements. So a few months ago, I spent a little bit of time advising on these issues, and what I saw, strangely enough, led me to believe that local authorities were pretty good at doing the difficult stuff, liaising with the NHS, evaluating capacity, demand, risks. There's a lot of technical stuff involved in that. Surprisingly to me, the areas where I saw that improvements could be made fell really within the procedural arena, which ought to be easy, involving all the right people in decision making, and above all, properly publicising the use of the easements as the guidance advises. So I think I am, yep, here we go, outlining the new framework. Well, there it is. I'm sure everybody is pretty familiar with that and will have read it all, perhaps many times. Just a quick word about the statutory guidance. Is para 18 of Schedule 12 of the Coronavirus Act. Requires local authorities to take it into account and then to comply with it insofar as the Secretary of State may direct. There aren't any directions as yet, so it is still, quote unquote, just guidance. Just a quick reminder though that, as many cases tell us, where guidance is nationally applicable, prescriptive in tone and intended to be normative, local authority will usually need to have a very good reason indeed based on local circumstances for taking a different course. Now, there you go, an outline of the new framework. I'm not going to labour this. I think everybody's going to be pretty familiar with what the Act does in outline. And on the face of it, the Coronavirus Act has pretty much destroyed adult social care as we know it by removing a whole raft of duties. But because of the guidance, the statutory guidance I referred to earlier, that isn't actually so. essentially because, as I know everybody is going to be aware, essentially that's because the guidance advises and in effect requires local authorities to exercise their powers under the Care Act as if that act was fully enforced, unless and until that becomes, for want of a better word, impossible. Even then, it requires new decision making in individual cases to mirror old decision making as it would have been done under the Care Act, to mirror that as closely as possible. So what remains unchanged? That's pretty self-explanatory. Just draw attention briefly to the PSCD there. So the guidance envisages sort of 4 lines of defence, as it were, or four lines of erosion of the duties. Here you go. These are the first, what I call the first 2 lines of defence. So first of all, at the first stage, local authorities are still assessing needs. They might be assessing them over the phone or on Zoom or in other more flexible ways. But the key point is local authorities are still operating under all the duties, or as if all the duties existed. They're simply meeting needs or trying to meet needs more flexible. For example, if a daycare centre suspends its activities or closes down for a while or even permanently, the local authority here in these 2 stages will still be recognising that it's under the same duties as it was under before towards attendees of that day centre, and it'll just have to do its best to meet those needs in different ways. If it's necessary to go further, one then gets to the next 2 stages of applying the easements, as you see there. Now, the critical question here is, when is the tipping point reached? And I've set out the relevant bit of the guidance there. I think most people will have read that several times. I mean, essentially, the tipping point is reached when the local authority just can't cope and something has to give, or acute needs won't be met. So I would usually expect to see a local authority assessing the numbers of hours of care that it currently provides across the board, the number of hours on its waiting list, which will obviously have to be met, new cases that are envisaged, taking into account NHS projections for discharges, that sort of thing. And I'd expect a local authority to be calculating pretty technically and accurately the existing hours of staff time that's available, and also the additional hours that could be obtained, for example, by offering higher payments, increased hours, using agency staff, or obviously a little bit longer term, engaging in a recruitment exercise. So that's the sort of tipping point. And here, I think it's worthwhile just pausing a little bit, because one potentially interesting point arises here. The guidance is focusing on an emergency situation that is current and present. But what about a case where, as a result of local authority discussions with the NHS, for example, the local authority decides that the resources available to it won't be sufficient to cope with projected demand in the near future, for example, because of projected discharges from the NHS? Can the local authority trigger the easements in order to avoid a tipping point occurring in the future? I would say yes, I think so, providing that it truly is a case where, unless action is taken now, there will be urgent or acute needs not being met, potentially risking life. I've seen that course adopted and not challenged, and I think it's lawful in those exceptional circumstances. The point overall, obviously, is at the end of the day to avoid acute needs not being met and people potentially dying. So, so here we go. The process for operating the easements is, in my opinion, very straightforward, and it's all set out clearly, pretty clearly, in the statutory guidance. And what I would say to local authorities is, why make life difficult for yourselves? Why don't you just read what the guidance says and comply with all the requirements to the letter? And you know, what I saw being missed out were kind of simple things, really. Communication to the Health and Wellbeing Board, and communication to all providers, service users, and carers, for example. Now, one might ask, well, why is communication to everyone required if in practice what the local authority is going to do with its particular form of implementation is only going to affect a small percentage? And I would say to that, well, I mean, there isn't a very good reason. And if local authority doesn't communicate its decision to everybody, it may well avoid a judicial review on the basis that it's got a good reason for diverging from the guidance. But is it worth it? All it takes is a pretty clear statement of reasons on the website, an advert in the local paper, keeping local voluntary groups informed, at worst, a letter appropriately expressed to everybody who uses services in the area. Publication as well. I mean, it may be that in some local authorities, the instinct will be to publicise implementation of the easements as little as possible. But I mean, based on what I've seen, I'd say that's not a good idea. The Department of Health and Social Care publicises which local authorities are operating the easements. And if you are a local authority who is implementing the easements fully, and you don't make it clear what you're doing and why, understandably, really, what you do is lay yourself open to all kinds of speculation and rumour as to what you've done and why, to letters before action demanding clarity, and it's not the right thing to do. The guidance is really clear. The action taken must be publicised, and when it's publicised, it can be explained. There we go. Those are the third and fourth lines of defence, which I think one all knows about. And then assessments, reviews, care planning still have to closely mirror, even when the easements are applied, what local authorities did before, and they have to take into account and apply the ethical framework. That's a little bit more of what the guidance says about assessments, reviews, and care planning. Prioritisation, funnily enough, this is obviously when the easements are implemented fully. The guidance doesn't actually give much of a steer on prioritisation. I've certainly seen local authorities using the red, amber and green RAG rate system, and in effect that means speaking with providers about which service users may fall within green, sort of those with the lowest needs who can be expected to cope with a withdrawal or reduction of services. And after speaking with providers, I've seen local authorities who've then spoken directly with the individuals concerned to make sure that that was the case and that their needs fell within this lowest band, and to check that they would be able to cope if some or all of the services were withdrawn. I've seen conversations recorded with consent, obviously, and monitored on a sort of trial basis by senior officers to check that everything is being done fairly, and you know, in an agreed sequence of reviews, of course, with those individuals, a package of measures to mitigate risks and make life easier, for example, help with shopping, medicine collection schemes, that sort of thing. Another way of looking at prioritisation would be to go back to prioritisation as it was under fair access to care services, and use that as a starting point for as a rational basis for prioritising under the easements. And just I'm not going to go through them. Older people like me will remember them pretty well, but they're just here for convenience, the old fair access to care services schedule of prioritisations. Convention rights, obviously, as was flagged up in the earlier notes, always have to be respected and not breached in every case. As everyone knows, I mean, there is a pretty high threshold for establishing that a failure to provide adult social care is in breach of the ECHR. It's a high threshold, as most of those cases illustrate, but it's not insurmountable. It was surmounted in Bernard, and although Limbuella was a case involving destitute asylum seekers, you know, it was surmounted there as well. So it's difficult, but it's certainly not insurmountable. Dealing with the market, I mean, obviously the adult social care market has you know, certainly aspects of it has been in a very difficult situation for quite some time. As far as concerns providers, it's probably way too late for them now, given the judicial review time limits, to apply for judicial review of decisions which would have been made in March or April, setting sort of standard rates for care home and home care charges, although, you know, you can't take that for granted. It's always possible that extensions of time might be granted, and it's always you know, a good idea, and it would definitely be good practice if some problem arises as between providers and local authorities, for local authorities to really check that the last review that they undertook did properly increase standard fees, taking into account inflation, increased national living wage, and that they did properly look at the relevant statutory and non-statutory guidance, most of which is summarised pretty usefully in the care and support statutory guidance. As I understand it, the first tranche of government funding for increased social care payments because of the coronavirus has ended. How future funding is going to be distributed, one's going to have to look primarily at terms of the funding. The Local Government Association has published a raft of really helpful notes about that, which I've given the web link for here. According to the Local Government Association, and possibly according to Common Sense as well, but you know, everybody has been very difficult, very busy. I appreciate that. Local authorities should have been monitoring the impact of COVID-19 on provider costs from April 2020, and if they've not done that and not been doing that, I think it would be a good idea to start now and do the best you can. The LGA said that they will be trying to monitor increased costs at a national level, but I'm not sure what's been happening in that regard. In any event, it wouldn't necessarily translate across into a particular local authority area. And the very helpful LGA note called temporary funding suggests what sort of matters local authorities should take into account. Now, with a view, obviously, to potentially distributing future funding amongst the market, or to using whatever resources the local authority considers that it has to help out the local market financially, possibly in other ways as well. Local authorities are obviously going to think first and foremost about well, possibly their own homes, and certainly the homes and domiciliary care providers that they contract with as commissioners, which is understandable, but just slight word of warning there.
because of Section 5 of the Care Act and Chapter 4 of the Care and Support Statutory Guidance, the local authority is going to have to look at the state of the market as a whole, and will need to at least consider whether it's necessary to provide some type of support, including potentially financial support, for homes with which they don't contract. You know, I mean, take it to the extreme.
You know, if half a dozen homes with whom the local authority hasn't got any placements at all go bust, you know, that's going to cause a massive problem locally and should be avoided if at all possible. So I think, you know, the judiciary has made it pretty clear so
far that they're going to look at coronavirus related litigation pretty carefully and aren't going to impose, you know, they're going to uphold the law, obviously goes without saying, but are not going to impose unrealistic demands in the current environment. But I would say to local authorities that, in my opinion, it would be prudent, as far as is humanly possible, to start to review their joint strategic needs assessment, their market position statement, and any other relevant local strategies, at least by starting a conversation and a process locally with stakeholders and people like that, so you can find out, you know, what's going on, and so that other people involved can know, you know, what your situation is. So I've dealt with that, dealing with the market fairly speedily. I think that's just something of an emerging issue, but I hope that's given a sort of reasonable introduction to that topic. So that's all that is coronavirus related that I wanted to talk about right now today. So with a bit of luck, Elsa and Leon will reappear shortly, and I'll find out if there are any questions, which well,
thank you very much. Someone is saying thank you very much for that, and that's so nice because, you know, and someone else is. That's great because we, you know, we're such divas. You know, we just miss the applause from live seminars, and there's lots of thanks, which is great. I mean, thank you very much.
It's a bit odd, isn't it, when you're doing a webinar and you just don't know if anyone is listening or caring or paying attention. So it's good to know that there are people out there.
I think someone left when I was speaking.
There are two questions, Steve, that have come on ordinary residents.
I can't see them. I'm so sorry.
Well, I think they were to me, so I'll read them out.
Oh, they just went straight to you. Go for it, then.
So I'm sure you will have some things to add on them. So the first one was in relation to the Secretary of State's determinations of ordinary residents under Section 40 of the Care Act, so where there's a dispute. And the question was, recently there's been a lot of reviews of determinations by the Secretary of State, and where do they come from and why is Secretary of State reviewing his determinations? The short answer to that, and I'll let Stephen add what he wants, is Section 40 provides for a system whereby there is a determination by the Secretary of State, and Section 40 subsection 2 provides for a review within 3 months, and it basically says that the Secretary of State has to either confirm the determination or otherwise. In practice, I assume what's happened is a determination and someone complains about it and or threatens judicial review, which then leads to a review. But it may be people just asking for a review because they've been found responsible. So there is provision in the statute for that to happen, and the Secretary of State is obviously using it.
There is one special reason as well, and I apologise for not having mentioned it to you, Leon, before today. I'd forgotten about it, although I had to do some advice on it, and one just wouldn't know if one wasn't involved in it. It's to do with Section 1173 of the Mental Health Act 1983. Which is the one which provides that when you, I'm paraphrasing very roughly from memory, where you are detained under kind of Section 3 and these other sections that are relevant to aftercare services, the responsible local authority, since we're looking at social care, is the one for the area where you were ordinarily resident, or I think it's ordinarily resident now, before you were detained. And it's always been the Secretary of State's position that means once you've been discharged from hospital, you can potentially become ordinary resident in the place of discharge. And so you can accumulate a series of different ordinary residences if you're sectioned in various different places. And so a series of different local authorities could become responsible for your social care. But the Secretary of State has now done a total volte-face. He's changed his policy about that and is now saying, by analogy with Cornwall, responsibility remains with the local authority for the, I think I'm right, the area of ordinary residence before the first section, providing there's an unbroken chain there's an unbroken period of aftercare services, and so there's been a lot of he's reviewed and reversed a number of determinations like that, and I think it's is it Worcestershire is now judicially reviewing him on the I would imagine on the basis that you can't just change your policy 180 degrees. Well, you can do, but you can't if that's incompatible with what the words of the primary legislation say. So that would be quite an interesting one. So that's one reason. Sorry.
Great, no worries. And there's one more that I have, and then I think a couple more have appeared. So the other one, I'll primarily hand over to you, Steve, I think, because you've been more on the ground on this. But if a person lacks capacity and is placed out of area in a care home funded on a COVID-19 pathway, and the plans for them to remain in that care home, which authority is responsible for arranging a deferred payment agreement? Quite specific. I mean,
well, I would have thought it would be the placing authority, but why wouldn't it be?
My hunch is that the Cornwall principle would just apply. So yeah, if you place them elsewhere, that was my hunch. But I didn't know whether you've dealt with any of those cases, those coronavirus cases.
No, and I'm not actually. I have to confess, I mean, I'm not. To be honest, I'm not sure whether the coronavirus pathway. I don't know what that is. I have to be completely honest there.
I think it's an NHS. So, it's mainly an NHS thing. Yeah. Okay. Well, that one we've maybe partially helped. There's two more, Steve, as well, which I think are on the chat function. If you can see them. Can you see these or not? Shall I just read this one out?
I cannot. I can see the chat function, but all I can see is thank you and ditto and stuff like that.
It's probably down the bottom. Well, the first one's that the first one I can see here is in respect of ordinary residents, and essentially it's quite long, but essentially the query is if there's a young person who has an education, health and care plan who's been placed on a 52-week placement outside the authority's area, they are then, it's the placing authority that's responsible. But then there's an oddity, because when they've also been found eligible for continuing healthcare funding, there's a different test because of the NHS Act, I think is implied, and therefore it's a different. Essentially, you get a mix-up of different providers or those who are responsible in this kind of case. And I think the short answer to that is yes. That's just the nature of the statutory machinery. For education purposes, I've already mentioned it's Section 24 of the Children and Families Act. For NHS funding, it's the NHS Act 2006, and I think it's, from memory, it's Section 2, which sets out who's the responsible commissioner. And the question is right to the extent saying it's the responsible commissioner it's the CCG in which has the GP practice of which the person's registered. So if you move GP practices, then the CCG may change. So in the Waking Day case, what may have happened is if young person was living at home and they have a GP near home and the local CCG is responsible and that local authority, they move to the 52-week placement, what might end up happening is that they get a local GP, then the CCG moves, but the local authority wouldn't have moved. So the thrust of the question is, it's a bit weird, and that's right, but that's just an outcome of the statutory machinery. Steve, is that roughly?
That sounds spot on to me. I'm really sorry if I'm just making a mess of this, but I can't see any more questions on the chat function.
I've got one more, which I think it's been messaged to me only, but I'll read it now. I haven't read it yet, so it's sort of anyone who wants to jump in. Oh, there's one that you, I think, may have seen, but I'll deal with this one first. Something we've come across a lot is both local authorities refusing to go to the Secretary of State and not taking accountability. Is there route to go to the Secretary of State, or can you only JR both local authorities for this failure, for ordinary residents' disputes, that is? And I will just make an observation. I think in terms of the context of that question, that may be from an individual's perspective, just from the person who's asked it. But I think what I would emphasise is, for if an individual is caught in the middle of a dispute, that's not what should be happening, and you essentially have to bring a claim against who, I guess, who you think is, or emphasise that to both local authorities, and one hopes it wouldn't end up meaning a claim has to be issued, but emphasise the fact that local authorities have to make the provision and they sort it out amongst themselves. It's for the local authorities to go to the Secretary of State. I don't know, practically, are there any tips you have, Steve?
No, that makes sense. And I just seen there is a question that's come up. I think it's a follow-on question from what I was saying about 1173, and it's what should local authorities do now? Because I think when I was involved in looking at this, the Secretary of State was consulting on changing his statutory guidance to reflect his new policy. I gather from the question he's now actually done that. So the die is cast, and he's standing by his review decisions, and is now being judicially reviewed for his pains by Worcestershire. So the question is, what should other local authorities do? And I would have thought, don't do anything, just wait to see, put everything on hold, and wait to see what happens in the litigation, which I'm assuming will go ahead. I don't see why it wouldn't, but one can check with Worcestershire. And I suppose hypothetically, any local authority that, if there are any local authorities with money to spare, I don't imagine there would be, they could potentially try and join in on one side or the other. But I wouldn't particularly advise that. Just wait to see what happens. And this comes back to one of Leon's overarching points, which is absolutely right, is that, well, probably both of them actually, but the first one, and the most important one, is obviously when local authorities and CCGs and other public authorities have these boundary disputes, the one thing that must never ever happen is that the individual or family at the centre of it all suffers. Someone absolutely has to take responsibility for meeting those needs fully and properly until the boundary dispute is sorted out. And it also sort of engages with Leon's other overriding point that, on the whole, courts react badly to boundary disputes being brought before them, and can often say a plague on both your houses, or say something nasty about both public authorities, but not always. Sometimes they welcome such disputes with open arms, and it can be quite difficult to work out. Like the Cornwall dispute, they loved it and they were very interested in it and dealt with it all the way up to the Supreme Court. No criticism of anybody involved at all. So I think this case is clearly going to be a case that the courts are not going to criticise Worcestershire for bringing. It's clearly a valid and important kind of structural point that will affect all local authorities going forward. So it's a very long-winded way of saying, just don't do anything but wait. That would be my advice. And obviously make sure that you know, the person at the centre of it is being properly provided for, which I'm sure would be the case. So I managed to successfully read one question. I don't know if you've seen any more, Yasa.
I haven't seen any, no.
And or Leon.
No, no more that I can see anyway.
Well, what we've not yet sort of managed to do is arrange a sort of virtual, glass of wine with everybody after all of this. I don't know how practical that would be, but anyway, we haven't quite got the technology to do that as of yet. So I just wanted to thank Leon and Yasa yet again for their excellent talks, and for everybody who turned up and listened and watched. I hope it's worthwhile for you, and look forward to seeing you again when we have another go, possibly with somewhat different personnel, on the 23rd, I think is the next one, which is next week. So, well, best wishes to everybody, and have a lovely weekend. Thanks very much.